All right. Welcome back. We've finally have an update in Scofield v. Guillard, the Tic Toc psychic case. Been a little bit quiet since the flurry of activity last week. And if you remember, last week we had filings for default, motion for default judgment of something like $1.8 million, motion to set aside the default, answer and counterclaims that the answer was just insanely late. So yeah, that's what we had last week. So before I get started with the new stuff, so one of the problems when covering such a train wreck is sometimes you miss things. And I skimmed over the answer. I went straight to the counterclaims because usually usually answers are boring. It's like I said when I skipped over it. It's admit, deny, or explain, and without matching up. Here's what they're admitting to. Here's what they're denying to. One to one, the complaint and the answer open together. It just usually isn't all that interesting. But one thing that just this would have been if you didn't know anything about this case already, this would have given you an idea of just how crazy it is. Because paragraph one, parties. Ashley Guillard partially denies the allegations in the first sentence of paragraph one of the parties' portion of the complaint pertaining to the allegation that Rebecca Scofield is an individual. And then she admits the rest. But so if Rebecca Scofield is not an individual, I mean, is she a turnip? Because the options are, individual or corporation, government entity. It, now, bearing all that in mind, I assume the reason she denies it is she's like, well, she's not an individual; she's a public figure, which she also isn't. But even public figures are individuals. But that's all I'm getting into with the answer for today. So, first thing we had, which I'm kind of annoyed, but also kind of not. So, I check this docket every day, and I'm recording this late at night on the 27th of February. The Idaho court clerks have they have a bad habit of putting things on the docket late and then post dating them the timestamp. Um, and so today on the 27th, we suddenly get a filing for the 24th, which is annoying, but not too annoying because I don't think I would have made a video just for this filing because it's not much of a filing. In fact, it's not. neither of the parties did file this. This is from the court. This is a notice of assignment to a United States magistrate uh, judge and a consent form for such a assignment. So basically, in federal court, you sue. The assumption is it's going to be heard by a district court judge, but it can be heard by a magistrate, and or in some cases, you'll have evidentiary hearings before a magistrate, but the trial will be before a judge. But so I'm just going to skim through this. It says, in accordance with District of Idaho General Order number 324, you are notified that the above entitled action has been assigned to a United States magistrate judge to conduct all proceedings in this case, including trial and entry of final judgment. And it says, an appeal from a judgment entered by a United States magistrate judge will be directly to the United States Court of Appeals for the Ninth Circuit, manner as you'd appeal from a district court. Um, and it says this is done. It's only permitted by consent of both parties. You can, you know, not give your consent and blah blah blah. So why did they do this? This is actually kind of surprising to me. So it says, how does this benefit me? Speedy trial rights in felony criminal cases require the district judges to give priority to trying those cases. Some require that civil rights be moved. Magistrate judges do not preside over felony criminal trials. As a result, a magistrate judge's trial docket is generally less crowded than those of the district court judges. So, what's surprising to me is the state of Idaho only has two federal district court judges. That they also have a one senior judge, which is basically retirement level. They hear some cases, but not a full caseload generally. But that's tiny. Two judges, and then they have like three magistrates, I think, three or four. So that's just a tiny, tiny, tiny federal judiciary for a state. Of course, Idaho is a small state population wise. Um, I've mentioned before I'm in Utah. I think we have 6 or 7, maybe 8 by now, district court judges and then a couple senior judges. Um, so that's the excitement on that one. Okay. The motion to strike defendant's answer, affirmative defenses, and counterclaims to the complaint. So a motion to strike is basically, hey, judge, ignore this. Ignore that filing. To summarize, basically, they're saying, hey, look, the answer with its accompanying counterclaims was way late. It's inexcusable. Therefore, you should ignore it. Of course, the same day, Ms. Guillard, the Tic Toc psychic, did file a motion to set aside default, and that hasn't been ruled on yet. So that kind of will be what decides, I think, whether or not this motion to strike is successful. But that being said, let's look into it. After the clerk filed a clerk's entry of default, defendant Ashley Guillard filed an answer and counterclaims. The answer and counterclaims are untimely, citing Federal Rule of Civil Procedure 12A1, big A1. And as usual, let's take a peek at the Federal Rules of Civil Procedure and our friend Rule 12A, time to serve a responsive pleading. Uh, A1, A1. So, in general, unless another time is specified by this rule or a federal statute, the time for serving a responsive pleading is as follows. A defendant must serve an answer within 21 days after being served with the summons and complaint. That's pretty simple. 21 days. It was closer to 40 days, 50 days. I'm not going to count, but it was way after 21 days. So, continuing, they are also procedurally improper because the clerk's entry of default has not been set aside and should not be set aside, I assume, uh, for the reasons set forth in plaintiff's response to defendant's motion for relief from a judgment or order pursuant to Federal Rule of Civil Procedure 60B. We looked at that, uh, both the motion for relief from the judgment, the motion to set aside the default, and we looked at the response saying, no, you really shouldn't. Um, and yes, they are correct. The clerk's entry of default has not been set aside, but it hasn't been denied either. So, um, and then footnote 1 says the counterclaims are also procedurally improper, in part because defendant attempts to name plaintiff's counsel who are not an opposing party, uh, citing Federal Rule of Civil Procedure 13. So, once again, looking at the Federal Rules of Civil Procedure, um, Rule 13 governs counterclaims and cross claims. And so we basically we have compulsory counterclaims, permissive counterclaims, uh, relief sought in a counterclaim. Uh, but here we have to look at Rule 13H, which is joining additional parties, which says rules 19 and 20 govern the addition of a person as a party to a counterclaim or a cross claim. And in this case, it would be Rule 20. Uh, Rule 19 is permissive or mandatory joinder of parties. Rule 20 is permissive joinder of parties. Um, and so basically, 20A, persons who may be joined. 1, plaintiffs. Uh, 2, defendants. So persons as well as a vessel, cargo, or other property subject to admiralty process in rem may be joined in one action as defendants if any right to relief is asserted against them jointly, severally, or in the alternative with respect to or arising out of the same transaction, occurrence, or series of transactions or occurrences, and any question of law or fact common to all defendants will arise in the action. So I think what what they are getting at here is this isn't arising out of the same transaction or occurrence, or is my guess. They haven't pled it very well, but then it's also, under Rule 13, which is for counterclaims. that's against existing parties. You've got to join parties. Well, in order to do that, you've got to serve them. So you, as far as counterclaims against Miss Scofield, Professor Scofield, yeah, that assuming the answer and counterclaims, uh, the court doesn't strike them, you don't need to hire a process server and serve them. It's part of an existing lawsuit. But to bring in new defendants, oh yeah, you've got to serve them. So they're they're not an opposing party. They're not involved yet, and they probably won't be. But let's move on. So the court should thus strike defendant's answer, affirmative defenses, and counterclaim to the complaint, either under Rule 12F or pursuant to its inherent powers. Let's look at Rule 12F. Motion to strike. The court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. Um, the court may act on its own or on motion made by a party either before responding to the pleading or if a response is not allowed within 21 days after being served with the pleading. So that's pretty straightforward. It's insufficient or immaterial since it's late. Um, and that's citing Lake v. Fellner from the District of Nevada in 2014. Uh, so that's not binding precedent since it's District of Nevada instead of Idaho, but it is persuasive, and it's more persuasive than some because Nevada is also in the Ninth Circuit. So even though it's another state's district court, it's still in the same federal circuit, the not in this case the Ninth Circuit Court of Appeals. So it's more persuasive than some. It and quoting that, it says here, defendant failed to properly answer the complaint until over a year after the time to respond had run and after an entry of default. Accordingly, it is within the court's discretion to dismiss defendant's answers, which are untimely and improper. Of course, in that case, it was a whole year. So it's not a one to one, but still. And then Webster Capital Financing v. Miltz Eagle LLC, also from the District of Nevada in 2011. Miltz Eagle failed to answer plaintiff's allegations until 4 weeks after the 21 deadline for the second amended complaint. Accepting the plaintiff's factual allegations as true, the court therefore strikes defendant's improper answer. Um, so that one's only 4 weeks after. So yeah. Um, and then citing JJ Sports Products versus Lawson from the District of South Carolina in 2019, uh, striking an untimely answer because the filing of an answer must always be timely. And that's filed February 27th by Stoll Reeves, Wendy Olson, Elijah Watkins, and Corey Carone. So once again, looking at it, I'm still of the opinion, since she is pro se, Ashley Guillard is pro se, it wasn't, I mean, it's late. It's very late. I still am leaning it's probably going to be heard. I could be wrong. You know, this is judges deciding what constitutes excusable neglect. Different judges have different standards. So, what will this judge do? It's hard to say. I'm still leaning, though, since she is pro se, that there wasn't excessive, running up of legal bills, chasing after her in the weeks she was late. So it's if it were a represented party, if it were a corporation, you know, I'd have a harder time seeing it. But in this case, I still see the judge ruling, well, it's excusable neglect. You've been very naughty. Don't let it happen again. And so I actually I said at the beginning that, you know, the individual, I actually remembered something else from the uh answer that I wanted to discuss very briefly. So, and this came up. I watched Emily D. Baker's coverage of it, and so I mentioned in my coverage of the answer. So Miss Guillard referred to Wendy Olson, the lead attorney's experience as a U.S. attorney, but then she also said later the attorneys have a combined 40 plus years of experience as US attorneys. And I said, US attorney is a term of art. It's we are US based attorneys, but US attorneys are very specific. And so I went and I looked up Wendy Olson, and so she spent 13 years as an assistant US attorney. That's a federal prosecutor. But then after that she spent 7 years as the US attorney for the District of Idaho. That's a big deal. That's a presidential appointment position. It's on par, the at the state level, that would be the attorney general, but she's the federal level top prosecutor for the state. So yeah, that gives you an idea of the level of attorneys that Professor Scofield hired. So with that, I'm going to be keeping an eye on this. Hopefully we don't go 10 more days without any updates. But yeah, this one was short and sweet, but for you guys, this is going to be a 2 video day. I'm not which one's going up first, so check them both out. I'll be updating the Brunson v. Adams lawsuit, which is at least equally delusional as this one. So, with that, thanks for joining me. Please like, share, subscribe, do all the fun YouTubey things, and I will see you guys next time. Bye bye.